Yes, Judge.
All right, so I told everyone to be here at 8:45. People were not here at 8:45. Then everyone knew that the jury was gonna be here at 9. So I'm assuming both parties want the court to let the jury know that somehow it's the court's fault that they're not in here at 9. And this time I am not gonna do it because everyone knew to be here at 8:45. And people were not here at 8:45. I was here at 8:45. And then we definitely were supposed to have the jury in the jury box at 9. So, what is the objection to the jury charge?
Nothing from the state, Your Honor.
Yes, Your Honor. The objections to the jury charge are as follows. On page 2 of the instructions, the court has instructed the jury on both the culpable mental states of intentional and knowing, and the secondary manner and means of intent to cause serious bodily injury. Neither knowing nor that secondary manner and means for serious bodily injury are alleged in this indictment. The grand jury only indicted Mr. McIntyre for intentionally causing the death of Mark Saldivar. We have included in our objections case law that supports our position that this is an inappropriate expansion of the different alternative manner and means of commission the state may rely upon that violates Mr. McIntyre's constitutional right to indictment by a grand jury, and it improperly expands the state's burden of proof. The law in Texas is well settled that the jury charge must be authorized by the indictment and cannot expand the manner and means alleged. That's Thomas versus State, 444 Southwest 3rd 4 at page 8, Texas Court of Criminal Appeals, 2014. Although the state may be permitted to plead multiple statutory manner and means in the charging instrument, it could choose to plead only one. But however, in so doing, the state is required to prove that the defendant committed the alleged crime using that specific statutory manner and means, and it may not rely upon any other statutory manner and means of committing the crime. This I will expand upon in the objections to the charge on knowingly and the act that creates a substantial risk of death. It's also instructed to the jury on the murder lesser included for the same reason, that when you authorize a lesser included by the indictment, that doesn't authorize additional mental states. The court yesterday had commented that it would be difficult to ever give a lesser included if it couldn't track the statutory language of all the manner and means. But we have cited to decision that I believe puts that issue to rest. That decision is, pardon me one moment. Castillo versus State, 7 Southwest 3rd, 253 and 258, Court of Appeals, Austin, 1999, citing Barnes versus State, Court of Criminal Appeals, 1983, 644 Southwest 2nd, 1. I believe that the law is well settled on that issue and that it would be error to charge the jury on a mental state in a manner and means not alleged. Going up to
But counsel, these are definitions. This is not application paragraphs.
Well, Your Honor, we are objecting to the inclusion of those portions of the language in the definitions because there's nothing that authorizes them, and in the application paragraphs. So we want that objection to be clearly comprehensive to every place where the alternative manner and means and the alternative mental state are alleged. Additionally, Your Honor, we object to the inclusion of definitions of both intentional conduct for the result and intentional conduct for the nature of the offense. While capital murder is a mixture and a hybrid of result-oriented conduct and nature of the offense conduct, I do not believe that that is universal across all different manner and means of committing capital murder. We cite to Alvarado versus State, 704 Southwest 2nd, 36, and 39 through 40, Texas Court of Criminal Appeals, 1985, that points out that it would be error to charge the jury on both intentional conduct as it relates to the result and intentional conduct as it relates to the nature when it is only a result-oriented offense. The state has alleged in this indictment only capital murder by means of robbery. If this was a nature of conduct-oriented capital murder, such as the killing of a child, it would be different, but I don't believe, since robbery is also a result-oriented conduct, I don't believe that we have any reason to charge on intentional act of the nature of the conduct. We also would point out to the court that I believe it was agreed upon by the parties last night that on page 9 of the last revised portion of the charge that was sent yesterday evening on the accomplice witness rule, that the language on page 9 after the phrase commission of the offense, comma, but it must tend to connect the defendant with its commission, does not track the statutory language and is redundant. And we believe that that places undue emphasis on the issue of tending to connect the defendant with its commission and waters down and glosses over.
What page is that on? Is that on the final draft that's been submitted?
Yes, Your Honor, I believe so.
But I mean, do we know so? What page?
Page 9,
It's
Judge.
page 9. I think we all agreed that that language should be taken out, but it appeared in the final version.
And where on page 9?
If you go up from the last, from the end of the paragraph, 1, 2, 3, 4 lines, middle of that fourth line, comma, but it must tend to connect the defendant with its commission, comma.
All right, I think my page 9 is different from yours. Let me see. Do you see what I'm saying, Jason?
My accomplice witness starts on page 7 of the charge that Barbara sent, so.
Well, you're probably right, because I put my objections in my footnotes. That changed the pagination. I didn't think of that. It's in the accomplice witness instruction, and it is the last paragraph of the accomplice witness instruction. So this would be section 9 of the court's charge.
And I'm sorry, what part of the language are you objecting to?
The fourth line from the bottom of section 9 reads, if you find that an offense was committed, comma, and the corroboration is not sufficient if it merely shows the commission of the offense. And we're objecting to the language after that comma, the phrase, but it must tend to connect the defendant with its commission. That phrase is already used a few lines above in that same paragraph, so it's redundant, and using it twice does not track the statutory language.
All right, that was agreed to be removed, so the court will remove that.
Thank you, Your Honor. The next issue that we have here is the court has excluded from section 11 under capital
Just a
murder.
moment.
Sorry, Your Honor. Yeah.
Maybe we approach her.
Why are y'all approaching?
Well, I wanted to explain why I'm late. I want to apologize to counsel in the court.
All right, apology appreciated, thank you. I have page 8. That's coming over there.
Your Honor, may I have the record reflect that apparently your discussion with able civil counsel from Houston paid off? The reason I'm late is Mr. Richard Horace showed up at my office at 8:30 this morning.
And
I'm gonna let him sit there. We've rested and we've closed.
all right, so you don't want to call him as a witness?
I think it's too late, and we've got a jury waiting and a jury.
No, do you want to call him as a witness?
No, Your Honor, I didn't even have a chance to talk to him other than to chastise him for 3 days of avoiding us.
All right, so you do not want to call him as a witness?
That's correct. Is that correct? Yes, Your Honor.
Yes?
Yes, we made that decision when we closed.
All right, thank you.
Thank you, Your Honor.
All right, thank you. All right, counsel, you may continue.
Thank you, Your Honor. The Section 11 begins the provisions for capital murder as charged in the indictment. The court yesterday in the informal charge conference indicated that it would not charge the jury on self-defense as it related to capital murder on the rationale that if in fact there was a robbery, you can't be justified in killing the victim of the robbery. And while I understand that logic, I do believe that it can be charged, and we've cited some cases that have addressed this issue. Most of them do not squarely decide whether or not it's appropriate, but there is no discussion from the court that criticizes the decision to instruct in these cases. We discussed yesterday at the informal conference, Horn versus State, 607 Southwest 2nd, 556, Texas Court of Criminal Appeals, 1980. That's, I believe, authored by Justice Sam Houston Clinton. The case in Horn involved the robbery of a pharmacy with multiple co-defendants, and my understanding is it was a transferred intent case, meaning that one of the co-defendants was killed by the defendant in the case in the course of committing the robbery of the pharmacy. And self-defense was at issue in that case, and the court agreed that it
So does
should.
this case have a transferred intent?
I'm sorry?
The instant case we're here for today, does that have transferred intent?
No, Your Honor, I was getting to that. I think that the question of transferred intent is not a distinguishing feature. I can't think of one reason why the mere fact of a transferred intent case would. I'm pointing it out simply because I can understand that a court might argue that transferred intent is a distinguishing feature, but I would disagree with that thinking, because if the intent was, I mean, the whole function of transferred intent is to say that in those types of situations, the lack of intent is irrelevant. And the argument for the exclusion of the capital murder self-defense instruction is that the intent of robbery undermines the right to claim justification. Well, if transferred intent is in play, we're saying that an argument about lack of intent to the specific deceased body is not a
All right,
consequential
so
fact.
the request for self-defense for the capital murder in this case is denied. Fisher v. State, Aguilar v. State, Jacoby, Hernandez v. State, they all say there's no self-defense for robbery. And the way this case was charged, this is a capital murder, alleged to be a capital murder because of the robbery. And you cannot have self-defense for robbery, so that's denied. What is your next issue, counsel?
Yes, Your Honor, I do just want, and I understand the court's holding, I understand that there's authority that contradicts the authority I cite. I'm not trying to say it's a bedrock principle of law. I do think that it is a murky issue that needs further clarification, and I think that the scale should be tipped in favor of the defense on that question, because there is, especially in capital murder, an additional concern about due process of law as it relates to the ability for the defendant to avail himself of all possible justifications, because the consequences are more severe. And I think that foreclosing that and saying that we can't really have those arguments because all of those arguments fundamentally boil down to disputes over the intent of the actor, and that those are best left for argument to the jury, is needlessly foreclosing a defense that would be available for the underlying murder. And in this case in particular, the underlying murder is being alleged as a lesser included.
All right, so the capital murder self-defense request for the capital murder is denied.
Yes, I understand, Your Honor. As to the lesser included defense of murder, the defense objects. I want the record to be clear, we do not want that instruction. We believe that the evidence in this case, if it can prove any guilt at all, would only be sufficient to prove the offense of capital murder and not a lesser included offense. That said, and that objection being made, we similarly agree to the charging of the jury on the alternative mental state, as I've said, and the alternative manner and means. let's see here, I'm almost done. I did not brief this issue, Your Honor, but because I'm not asking for proposed language, I do want to also lodge an objection to the inclusion of the law of parties. Obviously not, the portion of the law of parties instruction that explains mere presence is not enough to prove guilt. I believe that's applicable even if party liability isn't alleged or sought. But I believe that the law of parties statute in Texas is unconstitutional, that it's constitutionally void for vagueness because it does not apprise the defendant or any individual of common intelligence as to what is actually prohibited by law. And because of its indefinite wording, it ropes people into criminal liability who may not otherwise have had the intent to adopt, support, promote, assist, or encourage the conduct that's alleged
Isn't
in the
that why
indictment.
they have the mere presence is not enough?
I'm sorry, Your Honor?
Isn't that the reason why you have the instruction that mere presence is not enough?
Well, no,
to
Your
be
Honor.
a part of a party to allegedly commit an offense?
No, Your Honor. While the party liability statute does explicitly say the mere presence language, and so it is quite often the language that is cited, mere presence is not sufficient to prove liability as a common law principle of legal sufficiency that does not depend upon the Texas legislature to ascribe it a particular statute number. And we would be entitled to an instruction that mere presence is not sufficient to convict even in the absence of party liability. So that's why I was qualifying it. I'm not objecting to the court charging them mere presence is not enough. That is the law. I'm just objecting to the portions that authorize a conviction on a theory other than the concept that Mr. McIntyre was the actual shooter.
All right, so that's denied.
And then the filing I just filed with the court a moment ago while we were discussing scheduling was related to the court's decision not to include the statutory language. One moment. In 9.04 of the Penal Code, that a threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor's purpose is limited to creating an apprehension that he will use deadly force if necessary, does not constitute the use of deadly force. I believe that that's well authorized by the evidence that was received in this case. There are eyewitness accounts that place the front seat passenger of the car as holding a gun, but with the barrel pointed up to the roof of the car, which would I think raise the issue as to whether or not the gun was merely being displayed to demonstrate the ability to use deadly force. And I think that in a case like this, it's important not only because it's a possible theory as to how the situation actually unfolded, but it also is important to prevent the jury from improperly considering the use of the gun for purposes that would not amount to a robbery under Texas law. There are circumstances in which a gun may be displayed and there is a dispute about whether property was taken, where the jury might improperly think that the display of the gun constitutes robbery when it would require some additional quantum of proof beyond that for it to be a robbery, and that would invite a conviction on a theory not authorized by law. So I think that Mr. McIntyre will be materially prejudiced if that instruction is not there, particularly if the state tries to argue that they only need to establish that a weapon was displayed to be able to prove the robbery.
All right, and then there was a charge conference that was held off the record, so I'm aware of the state's previous answer with regards to defense's request. The request is denied. Anything else?
Let me just make sure, Your Honor. I think that that's everything. Just one moment. I've also included, Your Honor, requests for a mistake of fact instruction, as we discussed at the informal charge conference yesterday.
All right, that's denied.
Thank you, Your Honor. I do just want to make clear what was discussed at the informal charge conference, that if a self-defense instruction is not authorized for capital murder, then a mistake of fact instruction would be necessary to ensure that the jury properly is able to consider the arguments of counsel. And then lastly, Your Honor, the court indicated at the informal charge conference that defense of property would not be included. It was in an original draft of the court's preliminary charge, which I would ask, just out of an abundance of caution, be made part of the record for the purposes of appeal. But I have included that language here. I did change it to reflect the burglary of a vehicle. The court has indicated that burglary of a vehicle would not be a valid ground under defensive property. I spent a significant amount of time trying to find a case one way or the other last night. I can't find one that either way. I would say that a plain reading of the statute would authorize burglary of a vehicle, and that if it doesn't authorize burglary of a vehicle, it would lead to an absurd result in how we interpret the statute, because the statute authorizes people to use lethal force to protect tangible, movable property. But if I'm not able to use lethal force to protect tangible, movable property when it's being burglarized, then that seems to undercut the entire purpose of the law. I don't think that's what the legislature intended, and I don't think that's how a reviewing court would interpret the statute.
Well, what I can say is, what it says is there is a list of offenses that are included in that statute. And if they wanted to include burglary of a vehicle, burglary of a vehicle would have been listed. They list everything except burglary of a vehicle. They have burglary, they have arson, but there's no burglary of a vehicle. And if the legislature wanted to include burglary of a vehicle in that section of the penal code, it would have been easy for them to write burglary of a vehicle. They did not. And the court is going to follow the law with regards to that, so that's denied.
Yes, Your Honor, I do just want to make one final point on the record about that, which is that if we look at how 9.42 is worded, it does give the phrases the court referenced, arson, burglary, etc. It does not give their statutory numbers. It does give statutory numbers at length in other portions of that same chapter of the code. And we must understand that this is an old defensive theory that existed in 1974 and 75, and that predates many modifications of different other statutes that are listed. For example, the amalgamation of theft has resulted in a wider range of changes to how theft is currently authorized for prosecution in the penal code. None of those things are parsed out or nuanced in this either, and I think therefore that our interpretation of it should be considered by the court if it came to
That's
review.
denied. Is there anything else?
One moment, Your Honor, I just want to make sure.
Sure.
Oh, forgive me if I'm wrong. I have too many versions in my head. I know I did see in one version the 404B language we requested, but I'm not sure if I saw it in the final version. If the court could confirm that with me.
Page 27, Your Honor.
What did you say? Page 27?
Yes.
Okay.
For some reason, it's not coming up on my search.
It's under paragraph 16. It's not.
I see that now. Thank you very much.
All right, and you wanted that included, correct?
Yes, absolutely. I just want to make sure it got in there. I would also request that the court give an instruction that tracks the language of Rule 613 of the Rules of Evidence
Right,
to
that's
inform the
denied.
jury. Apart from that, Your Honor, I believe that everything else is detailed in either the supplement or in the original objections that were filed last night. And so, if the court would accept for the purposes of the record, I would like to just object to the entirety of the charge given outside the presence of the jury
All right.
before the court reads the charge.
All right, that's denied.
Thank you, Judge.
You're welcome. And counsel, here's a copy of defense. This is a copy of your objections, so if you want that admitted into the record for purposes of appeal,
Yes, Your Honor, I would like to do that now.
Yes.
And then.
And I don't know what number you're all on for the record.
Oh, well, I mean, I don't, because it's a filing, I don't think, it will be in the clerk's record. I don't think it needs to be admitted as an exhibit.
Okay.
So,
If you wanna,
I mean, it doesn't hurt, why not?
Yes.
It's just, I would really hate if that's the reason. And then, of course, I did file that supplemental while we were sitting here at the court, which I won't have, I don't think it will even be accepted by the clerk until later today.
all right, if you will, email that to the court, we can print it out, and then you can include it with your, with that.
Thank you, Judge.
Charge.
All
And I
right.
don't know, defense, you may wanna put at the top of that, that is your requested,
I'll just
jury
hand write that.
instruction. You
Yes, Your
just
Honor.
Probably write it on there. And counsel, what I would suggest is the additions that you have, if you'll just print that out as well, and you can just combine it in that one.
Thank you, Judge.
You're welcome. So we're off the record briefly. Mr. Goldstein, IT is here so they can see if they can get your information to show on the screen.
I don't wanna interrupt anything you're on.
No, it's not a problem.
Can I do it while they're here?
Oh, yeah.
While you're here?
Yes,
Thank you.
sure.
You're my man.
And then, Your Honor, if we, I have one other thing just real quick to say on the record. Yesterday, Mr. Goldstein tendered several defense exhibits for the purposes of the record related to the Richard Horace issue. And in the trial, after the state's objection was sustained, I had asked the court and the reporter to note my exception to the exclusion of my questions. I would just ask that Mr. Goldstein's exhibits that were filed for the purposes of the record also be taken in by the record as a bill of exception to the trial court's ruling on the questions that were asked in the trial. I just do that so that the bill's complete, because I realize that they're not connected up otherwise.
All right.
Your Honor, I think they kicked back my attachment to you yesterday, so if I could just put this on a flash drive,
Yes.
that'd be easier.
Yes. And each side you have 30 minutes. Sure.
Judge, may I have
Actually,
a,
that's gonna happen, the exodus is gonna happen in a second.
Yes.
may I have a warning when I hit 10 minutes?
Continue.
Thank you.
Do you want any warning, counsel?
If I could have a warning when I have 12 minutes left.
So just so I can make sure I have the times correctly, how are you all breaking up your time? Because you're saying you want 12 minutes left?
The general plan is that I'll do 20 minutes, Mr. Goldstein will do 10.
Okay.
So that, I think, is the idea.
So you wanted after 8 minutes, so you're, is that right? You said the morning when you have 12 minutes left?
No, I'm sorry. When there are only 12 minutes left in our total 30-minute time allotment. 2 minutes before I'm supposed to stop.
Okay.
At the 18-minute mark, if you could let me know that I'm getting close.
You both have 30 minutes, so are you all dividing your time, or do you just want me to let you know when the defense has only 2 minutes left? How do you want it divided up?
I'm so sorry. The defense has 30 minutes total, right?
Yes.
Okay. I wish to speak for 20 minutes of that time.
Okay.
And when I only have 2 minutes before I have to stop speaking to give Mr. Goldstein a chance to speak, I'd like the court to let me know, which I believe would be 18 minutes
Yes.
past the starting time.
All right. I will make sure you have that.
Thank you.
And then, Megan, how you did? Oh, I'm sorry.
He's trying to get it.
Okay, sure. And then how are you all dividing your time?
Me 10 minutes, Jason 20, so I could have just notice when I hit 10 minutes and then keep like a 5-minute warning before ending.
All right.
Thank you.
And then, Your Honor, if the court will just, will the court be giving us at least pause of our time while we switch computers.
Oh, sure.
Thank you.
And mine still being.
Here's the supplemental request.
Okay. So, no, it happens. So did you know that extra section? Yes. So what I can do is I can print out. Yeah. All right. Thank you, all right. Oh, I got a copy. All right, thanks. Goodbye. Bye. All right, who's here? Jefferson Cano?
I am going.
All right, so, can I have attorney's approach?
May I continue to work on?
Yes. And we're not on the record.
That's what we're trying to get.
Okay, awesome.
We wanna show
And,
you.
Papa, just give me a moment to eject this so we can have it.
Thank you, Judge.
Excuse me, hi.
Hey.
Next
I'm sure.
All righty, let's line the jurors up. All right, let's line the jurors up. So everyone, the equipment works? I don't wanna put it out in the universe, but I should put it in the universe, right? All right, and if y'all can make sure you have your microphones on your lapels for the court reporter.
Yes. Can you hear me? Sounds like an ad.
Check, check, check.
All right, each side, y'all have 30 minutes.
We're not gonna give the charge first?
Yes, I'm gonna read the charge.
That's,
Unless y'all, is anybody gonna keep the charge a secret?
I was hoping not here.
Well, you know what's so funny? Well, it's not really funny. So I was trying a case in one of the precinct courts, and I was telling the judge, excuse me, I think the jury charge needs to be read. And you know what that judge told me? I'm charging them to go deliberate.
I like that.
And that was an elected position. Should I say who it was?
I'd like to know.
Okay. And then that judge also made us do pretrial motions in front of all the witnesses. Wouldn't invoke the room. I'm sure they'll be fine. But,
Did it help?
oh no, we have to do it. But it helped.
Ready?
Oh,
All right.
just one second.
Never mind.
We're back on the record in 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced?
Megan Galloway and Jason Garahan for the state of Texas.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre. He's present in the courtroom. We're ready to proceed.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please see it. All right, ladies and gentlemen, you've heard all of the evidence that you're going to hear in the case at this time. What I'm going to read to you is the charge of the court. It's a jury charge. You do not have to memorize it. The original will be sent back with you when you begin your deliberations. Charge of the court. Members of the jury, the defendant Tamar McIntyre stands charged by indictment with the offense of capital murder alleged to have been committed on or about the 23rd day of April 2017 in Bexar County, Texas. The defendant has pleaded not guilty. 1. The law regarding murder. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2. The law regarding capital murder. Our law provides that a person commits the offense of capital murder when such person commits the offense of murder by intentionally causing the death of an individual in the course of committing or attempting to commit the offense of robbery. 3. The law regarding manslaughter. Our law provides that a person commits the offense of manslaughter if he recklessly causes the death of an individual. 4. The law regarding robbery. Our law provides that a person commits the felony offense of robbery if, in the course of committing theft, as defined hereinafter, and with intent to obtain or maintain control of the property, he intentionally, knowingly, or recklessly causes bodily injury to another, or he intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. 5. The law regarding theft. Our law provides that a person commits the offense of theft if he unlawfully appropriates property with the intent to deprive the owner of property. 6. Applicable statutory definitions. Appropriation and appropriate mean to acquire. Appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to effect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. A deadly weapon means a firearm or anything that in its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether expressed or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. In the course of committing an offense means conduct that occurs in an attempt to commit, during the commission, or immediate flight after the attempt or commission of the offense. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. 7. Definitions of intentionally, knowingly, and recklessly. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 8. The law regarding parties. Our law provides that a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another, which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. 9. The law regarding an accomplice witness. You are instructed that an accomplice witness, as the term is here used, means any person connected to the crime charged as a party thereto, and includes all persons who are connected with the crime as such parties by a lawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness's testimony unless the jury first believes that the accomplice witness testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of the offense. The witness, Joanna Reyes, is an accomplice if an offense was committed, and you cannot convict the defendant upon her testimony unless you first believe that the portion of her testimony that ascribed guilt to the defendant is true and shows that the defendant is guilty as charged. And then you cannot convict the defendant upon said testimony unless you further believe that there is evidence in the case outside the testimony of Joanna Reyes tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, and then from all of the evidence you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. 10. Self-defense in defense of third person or persons. You are instructed that it is a defense to the prosecution if the conduct of the defendant was justified by the law of self-defense or defense of a third person or third persons. You are instructed that a person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. The use of force against another is not justified, 1, in response to verbal provocation alone. Just one moment. 2, if the actor provoked the other's use or attempted use of unlawful force, unless A, the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot safely abandon the encounter, and B, the other nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another, 1, if the person will be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The actor's belief that the deadly force was immediately necessary is presumed to be reasonable if the actor, 1, knew or had reason to believe that the person against whom the deadly force was used, A, unlawfully and with force entered, or was attempting to enter unlawfully with force the actor's occupied habitation, vehicle, or place of employment or business. B, unlawfully and with force removed or was attempting to remove unlawfully and with force the actor from the actor's habitation, vehicle, or place of business or employment. Or C, was committing or attempting to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. 2, did not provoke the person against whom the force was used. And 3, was not otherwise engaged in criminal activity or other than a Class C misdemeanor that is a violation of a law or ordinance regulating traffic at the time the force was used. presumption of a reasonable belief applies unless the state proves beyond a reasonable doubt that the facts giving rise to the presumption do not exist. If the state fails to prove beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the jury must find that the presumed facts exist. If the jury has a reasonable doubt as to whether the facts giving rise to the presumption do not exist, the presumption applies and the jury must consider the presumed fact to exist. Even if the jury finds that the state has proven beyond a reasonable doubt that the facts giving rise to the presumption do not exist, the state must prove beyond a reasonable doubt each of the elements of the offense charged in the indictment. A person, one, who has the right to be present at the location where the deadly force is used, and two, who has not provoked the person against whom the deadly force is used, and three, who is not engaged in criminal activity at the time of the deadly force is used, is not required to retreat before using deadly force. If all three of these factors are met, then in determining whether such actor reasonably believed that the use of force is necessary, a finder of fact may not consider whether the actor failed to retreat. A person is justified in using deadly force against another to protect a third person or persons if one, under the circumstances as he reasonably believes them to be, the actor will be justified under the law of self-defense, as instructed above, in using deadly force to protect himself against the unlawful force he reasonably believes to be threatening the third person, a person he seeks to protect. And two, the actor reasonably believes that his intervention is immediately necessary to protect the third person or persons. Reasonable belief means a belief that will be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use, or intended use, is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition, including death. Serious bodily injury means serious bodily injury that creates a substantial risk of death, or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. You are instructed that the defendant is not required to prove the justification, defense of self-defense, or defense of the third person or persons. The state must prove beyond a reasonable doubt that the defendant was not justified in his actions. Thus, even if you unanimously find beyond a reasonable doubt that the defendant has committed an offense, as instructed herein, the state must still prove beyond a reasonable doubt that the conduct of the defendant was not justified. 11. Capital murder is charged in the indictment. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of April 2017 in Bexar County, Texas, the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, did intentionally cause the death of an individual, namely Mark Anthony Salvador, by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm. Tamar McIntyre either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes was in the course of committing or attempting to commit the offense of robbery of Mark Anthony Salvador, then you will find the defendant, Tamar McIntyre, guilty of the offense of capital murder as charged in the indictment. You will not consider paragraphs 12 through 15. But if you do not so believe, or if you have a reasonable doubt thereof, then you will acquit the defendant of the offense of capital murder as charged in the indictment, say by your verdict not guilty of the charged offense of capital murder, and proceed to paragraph 12 to consider whether the defendant is guilty or not guilty of the lesser included offense of murder. 12. Lesser included offense of murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of April 2017 in Bexar County, Texas, the defendant, Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes, did intentionally or knowingly cause the death of an individual, namely Mark Anthony Salvador, by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm, or the defendant Tamar McIntyre, either acting alone or together as a party with Jalen Bell, Jeremiah Rodriguez, and or Joanna Reyes with the intent to cause serious bodily injury to an individual, Namely, Mark Anthony Salvador did commit an act clearly dangerous to human life that caused the death of Mark Anthony Salvador by shooting Mark Anthony Salvador with a deadly weapon, namely a firearm, then you would next decide whether Tamar McIntyre was justified under the law of self-defense or defense of the third person or persons. You will skip over paragraph 13. Do not consider the lesser included offense of manslaughter, but instead proceed to paragraph 14. But if you do not so believe, or if you have a reasonable doubt thereof,